So you're missing about 20 people. Probably if they're all coming, trying to get through all the traffic. What's your feeling about it? Remember that thing was probably a river. Psychological effects. Horrible. And I learned it. I'm glad you're not working. I don't take them from my class. Since I was an A. Good morning. We haven't forgotten you all, but we still got 20 people who say that they're coming. So give me a chance to get roadblocks to eat. Well, the roadblock to guard. Mark. When you're ready. Okay, want me to turn it on? Go ahead and turn it on, because otherwise I'll have to take. Not that people are usually shy about telling you. Train that they're not actually flying where we can take one right. I just did something to do that. Yeah, I tell them out. We've done it like a while. I haven't had any issues but she didn't even know anyone stuff. My mom, literally right though. She came in last. Friday, I was on the train. Yeah. But right, yeah, but it's just another issue. There's a lot over our right. Tower Road, like out there, so like always a lot of stops more that get to the airport. And the parking lot is like open there. And they'll have to be planned and then she hopped on. Yeah, so I haven't eaten that. But it's nice to then, I mean, that's literally got there. It's great. Yeah.
Okay, and you're up on everybody else. they're obviously stuck in traffic for the duration. Well, yeah, my experience coming from the east is that really you go around and come from the south. You really want to get here.
Yeah.
But thank you all for coming. One sad note before we start. Those of you who know our colleague Amy Poland, that's the way it is. So if you remember Andy, your prayers, and if you want information about services, we'll give you that afterwards. But our purpose here today is to listen to Brooke Khaleesi, and I'm sure many of you work with Brooke on a daily basis. Yes. Brooke is now one of our seasoned members of the department. She's been with us ever since she was an associate. I personally watched her face down Judge Lynch in an oral argument. So take it from me that she's a very talented attorney and a good advocate in front of judges. And all of you would be well advised to seek your counsel on any topic having to do with labor and employment law, but especially on sex under Title VII.
Thank you, Beth. It's a very kind introduction, although actually what happened is Judge Bates told me to sit down and that he didn't want to hear another word out of my mouth. So whether that constitutes standing up to him, I don't know, but it was certainly a defining moment in my career. Welcome, everyone. This is, I think, a very timely and interesting topic, also a very political one, and certainly can be a very sensitive one. As I am a lawyer in typical lawyerly fashion, I will give you a disclaimer. My concern today is to take a look at this issue under Title VII as a legal statute and as a legal framework that we are all familiar with. None of my comments should in any way be interpreted to be a reflection on, as a matter of right or wrong, whether additional protection is needed for any kind of group in the employment situation. My concern is how does Title VII address these issues, and is it an adequate statutory framework to do so? So with that disclaimer, let's get started. We've all seen these symbols, right? They're on 99% of the bathrooms that you'll ever see. My kids learn which bathroom to go into based on the picture, right? Symbols like this are becoming increasingly irrelevant, in my view, with respect to sex discrimination. And in the views of an increasing number of courts, certain agencies, these are becoming discriminatory. So our goal today is to kind of walk through how sex has changed under Title VII, give you some information on how courts are starting to broaden the meaning of sex under Title VII, and hopefully give you some pointers on how you can adopt your policies and your procedures to make sure that you are encompassing the full scope of the meaning of that term as it's increasingly being interpreted by the courts. I'm happy to take questions as we go. We'll also try to have questions and answers at the end as we go through. Okay? So let's start out with a little bit of history with sex under Title VII. This is actually the language of the statute. And there's three words that are the key words for purposes of the analysis, and it's because of sex. That is the prohibition in Title VII, is prohibition against discrimination and retaliation because of sex. Starting out, there was a very, very narrow view of sex under Title VII. Title VII was passed in 1964. It was a statute primarily about race, at least in terms of congressional debate. Sex was added at the last minute with practically little, no analysis or congressional debate, which is significant for a couple of reasons. Number one, we don't really have a legislative history to look to in terms of what did Congress mean when they said because of sex. And second, as we have more and more courts starting to talk about what did Congress mean when it said because of sex, Not to say that they're making it up, but there really isn't anything to point to support the notion that Congress had a specific view of sex one way or the other. So we're kind of going blind. This is, court-developed doctrine in a lot of ways. So very early on, the first couple of decades, 25 years or so after the passage of Title VII, the courts took a very limited traditional view of the term sex under Title VII. Couple of examples of those cases. Holloway versus Arthur Anderson out of the Ninth Circuit, believe it or not. Basically, sex equals chromosomes, right? You are male or you are female, and those are the two categories, and that is how discrimination is evaluated under Title VII. So the question in Holloway was, can an employee be discharged for initiating the process of a sex transformation? And the court said yes. Title VII was about race, not sex, and that there was no proof that transsexuality is a, quote, immutable characteristic. When Title VII was first passed and in the years thereafter, race and sex were viewed similarly in that they were considered immutable characteristics. You were what you were, and it was male or it was female. And they indicated in their holding that changing sex was not discrimination because of sex, not discrimination because you're male, or discrimination because you're female. It was discrimination because you're changing sex, and the court was not willing to extend Title VII's prohibition to this particular fact scenario. Similarly, a case out of the Seventh Circuit, which sits in Chicago, this was a case out of the early 80s, Lane versus Eastern Airlines also dealt with the transsexual situation, a sex change from one to the other. The court affirmed what they believed to be the congressional intent was that there would be a very traditional view of sex under Title VII. And this is language that I think is important because it sets up what the courts were looking at in the 70s and the 80s, and it's language that we can use to evaluate where the cases are going now, to ask ourselves whether Title VII really is an appropriate vehicle to cover the issues that are currently at issue in the workplace. So the court in Lane used the language women because they are women and men because they are men. That is the prohibition in Title VII. You cannot discriminate against a woman because she's a woman. You cannot discriminate against a man because he is a man. And that is where the court drew the line in this case. So sex was biological. You were male, you were female. It was based on biology. It was based on chromosomes. That was the early view of sex. So then we get to 1989 and the case of Waterhouse versus Hopkins, which not just in the realm of the types of issues we're discussing today, but for sex discrimination overall, I think represented a fairly significant departure from the traditional view of sex discrimination. Ann Hopkins, a female, was denied partnership at Waterhouse. And unlike the more traditional view of a sex discrimination case, apparently Waterhouse didn't have any problem whatsoever with making a female a partner. This was not a case where females were considered the lesser sex, not qualified, shouldn't be in the workplace, those types of things. They had no problem with it. They had lots of female partners. The problem in this case is that Hopkins was subjected to the types of comments that you see here on the screen. She was called macho. She was accused of overcompensating for being a woman. They told her she needed to go to charm school, that she used too much profanity, and they suggested that she wear more jewelry, a different hairstyle, dress a little bit differently. Essentially, her claim was, I am being discriminated against because I am not feminine enough, which is not, if you look at it, really the traditional male versus female sex discrimination case. She wasn't claiming, you're discriminating against me because I'm female. You're discriminating against me because I'm female and you don't like the behavior that I'm exhibiting. So the United States Supreme Court ruled in Hopkins' favor and established the whole notion of discrimination on the basis of sex stereotyping. So a behavioral-based decision, not biology, not chromosomes. And the Supreme Court said, if you discriminate against someone because they do not exhibit the characteristics that you believe a woman should exhibit or that you believe a man should exhibit, that is an actionable claim for discrimination under Title VII. Okay? So again, much different than the original cases, right, where it was all about biology. Suddenly we're looking at behavior. And I would argue that as you start moving away from biology, again, ignoring completely the issue of right or wrong, you start getting a lot more muddled in how Title VII is going to actually apply to these cases. So Waterhouse is incredibly important given the current cases that have been dealing with issues of transsexuality and transgender and gender identity, because without Hopkins, there really is no legal authority for any of those cases. And we'll talk about that a little bit more here in just a few moments. One other case that I want to mention that I kind of consider one of these gatekeeping cases that kind of helps segue in the change from the traditional view of sex to some of the newer interpretations is on-call versus sundowner offshore services. This was a case, again, Supreme Court, Justice Scalia wrote the opinion, that dealt with some overtly sexual conduct by male employees directed towards another male employee on an offshore drilling rig. Okay? And it's really nasty, nasty stuff. Threats of sexual violence, really ugly, ugly conduct. But the question was, could on-call bring a claim of sex discrimination, sex harassment, when the perpetrators of that harassment were male, same sex as he was? And could he bring it when there was no indication that the sexual orientation of the perpetrator made a difference? Now, the Supreme Court, in a case called Meritor Savings Bank versus Vincent, had ruled that hostile work environment sex harassment was actionable. But implicit in that decision was a very heterosexual view of the world, right? The notion that a man might have overtly sexual conduct directed at a female coworker, but would not direct that conduct at a male coworker. This was asking a different question. Could a male bring a sex harassment claim against another male? And Justice Scalia quoted some language out of Meritor Savings Bank. The Title VII evinces a congressional intent to strike at the entire spectrum of disparate treatment of men and women in employment. So taking a very expansive view. Now again, we don't know exactly where that congressional intent comes from, and so it's not from the congressional record. And the other notable issue is the phrase disparate treatment, right? Still some notion that inherent in a sex discrimination claim is a difference in treatment between one sex and another, okay? But nevertheless, Justice Scalia and the Supreme Court concluded that you cannot assume that a male would not discriminate against another male, or vice versa, that a female would not discriminate against females. And the conclusion of the court was that same-sex harassment was actionable under Title VII, irrespective of the sexual orientation of the perpetrator. Okay, so whereas the more traditional view of a sex harassment case would be viewed through a heterosexual lens, right? Men harassing women or women harassing men, the court concluded that there is a harassment claim, and it doesn't have to be based on the sexual orientation of the participant. So, I mean, to me, that begs the question, is this disparate treatment because of sex? Do we know how these perpetrators would have acted toward the woman on the rig? Or are we simply talking about a situation where it was presumably an all-male workforce and on-call was male, and that happened to be the target of their conduct? So there was sexual conduct. Was it conduct because of sex? And I think that's a question kind of left hanging by the Supreme Court's decision in on-call. But this is important because it together with Hopkins, provides some of the legal basis for where the courts are going with these cases. So that's kind of where we were. That's kind of what the early cases indicated, kind of the sea change we had with Hopkins and with on-call. Let's talk about some definitions. I have pulled these out of a 2015 EEOC administrative decision. They probably could vary depending on who you speak with. So just so you know, this is where I got these. Lusardi versus McHugh had some various definitions in it concerning these new issues of transsexuality, transgender, gender identity, gender expression, because that is where the courts are starting to take the because of sex prohibition in Title VII. So according to the EEOC, transgender is an umbrella term for persons whose gender identity, gender expression, or behavior does not conform to that typically associated with the sex to which they were assigned at birth. Okay? And we'll talk in a minute about the specific definitions of gender identity and gender expression. But I want to point out that under this definition, remember Ann Hopkins, the woman who was too macho in Waterhouse? Under this definition, she is transgender. Even though that case had nothing whatsoever to do with a sex change, it didn't have to do with sexual orientation in any way. Her behavior did not conform with the traditional view of how a woman should behave. So under this definition, she's a transgender individual. Okay? Gender identity is a person's internal sense of being male or female, both or neither. Okay? So gender identity is a sub definition under transgender. One issue with gender identity that I can see coming up in the workplace is someone's gender identity necessarily something that will be obvious to a third party? Okay? The way the cases are going, and we'll talk about some of them here in a minute, gender identity is becoming increasingly protected under Title VII and Title VII's prohibition on discrimination because of sex. But theoretically, you could have a situation where an employer's coworkers, you don't know what someone's gender identity is because it's inherently internal initially. Okay? And gender expression is defined as a way a person communicates gender identity to others through behavior, clothing, hairstyles, voice, or body characteristics. Okay? So for example, in the case of someone who is transitioning from one biological sex to another, there was a point at the process where they start living as the sex that they are becoming. That would be an example of gender expression, of expressing their gender identity. But I'll also point out that there's not necessarily any requirement that gender identity be outwardly expressed in order for it to be protected under Title VII. And remember Ann Hopkins, we still have this notion of behavior, right? Behavior does not need to be tied to a gender identity situation or to a sex transformation situation to be covered under that definition of transgender. So we're dealing with, in my view, a very broad realm of possible situations that could now be implicated by Title VII because of sex. Yes?
Are these additional definitions still from that EEOC?
Yes. Yes, these are all from the EEOC decision. Okay. So I want to talk a little bit about how the courts and various agencies, including the EEOC, have started addressing these various issues of sex and gender under Title VII. So we saw early on that initially it was a biological question, an issue of chromosomes, an issue of biology. The courts have now come out and started to explain that because of sex is not simply a matter of biology. It's also a social issue, a social question. It deals with behavior. It deals with psychology. It deals with gender identity, that internal sense within an individual. And as an example, I've tried to pull a case that kind of represents each of these. There was a case out of the Sixth Circuit in 2004, Smith versus City of Salem, that dealt with essentially an Ann Hopkins situation, but it was applied to a transsexual situation. So we had somebody who was transitioning from one biological sex to another. And the court held that the person's conduct, behavior, how they dressed, how they acted, would not have been criticized if the person was, in fact, biologically female. They were living as a female, expressing themselves as a female. Biologically, were still male. Okay? So the court held that that was discrimination because of sex, because the behavior would not have been criticized if the person was biologically female. Probably seems like the right answer from the sense of right and wrong. I find it kind of curious that in order to find discrimination, you have to rely on the person being biologically male, which is not the gender that they feel themselves to be, nor the gender or the sex that they want to live their life as, right? So it very quickly becomes exceedingly complicated to kind of parse out these issues. But that's how the case developed with respect to this. So they essentially took Hopkins and applied it to a transsexual situation, focused on the behavior, the conduct, looked at the biological sex of the person at that time, and concluded that this was, in fact, sex discrimination. Another case, I find this a very interesting analogy out of the D.C. Circuit 2008, Shore versus Billington. Bullet point here, number 2, the court equated gender to a religious conversion, right? So remember how in the very beginning the courts talked about sex as an immutable characteristic, right? just like race. The court in Schwartz said, look, if you look at Title VII, there's no doubt that Title VII would protect a Christian who converted to Judaism, right? So why should it be any different with respect to sex? If we have an individual who is transitioning from one sex to the other, why would Title VII not also protect that situation where it would protect the religion? So clearly the court is starting to look at this as not an immutable characteristic. It's something more like religion that can change. Okay? Bullet point number 3, transgender equals those who contradict stereotypes. Several courts have started defining a transgender situation as one in which the person does not conform to sex stereotypes. So they almost set up a per se, essentially a per se situation of sex stereotyping if there's any action taken based on someone being transgender. Because they say, you know, by definition, that means you don't match the sex stereotypes of your employer. And this was expressed in Glenn versus Brumby, a case out of the 11th Circuit. Interestingly, the 11th Circuit spoke on this issue just this week. I'll tell you about that case here in just a minute. Frankly, didn't do a whole lot to clarify things in my mind. But in the past, they have expressed this notion that sex stereotyping is almost an automatic when it comes to transgender situations. And then finally, I want to say a little thing about how sexual orientation is being handled. Now, even as courts are trying very hard to take these ever-broadening issues and kind of cram them into the because of sex language, most of the courts have been adamant that Title VII does not protect sexual orientation as a status. Title VII does not protect transsexuality as a status. Right? They are using the sex stereotyping theory to wrap these issues into Title VII. They are not saying that as a class or as a status, sexual orientation or transgender situations are protected. Okay? So as a result, sexual orientation is treated differently or is separate from a transgender issue under federal law. Now, interestingly, under state law, you may know that our state Anti-Discrimination Act protects sexual orientation as a class in the statute. In the definitions of sexual orientation at the state level, transgender is included along with heterosexuality, homosexuality, and bisexuality, probably to make sure that everything was wrapped into the protection of sexual orientation, but that's a pretty different treatment in my view. Under federal law, sexual orientation is still distinct from transgender issues. So we have several interesting developments with respect to sexual orientation. Courts are still saying it's not protected as a status. However, the EEOC has filed, if they haven't been filing the lawsuits themselves, they've been filing an increasing number of amici briefs, friends of the court briefs, where they've expressed their views on these issues in various lawsuits. And they have 3 theories as to how sexual orientation is in fact protected under Title VII. First of all, they continue to maintain that it should be protected as a status. There's not much statutory authority for that, but that's their position and has been for a while now. But they also come up with 2 other arguments for how sexual orientation is protected under Title VII. The first is the sex stereotyping theory from Ann Hopkins, right? That sexual orientation discrimination reflects discrimination because someone does not conform to stereotypes based on sexual preference, sexual attraction, and so forth. So they continue to put forward the sex stereotyping theory. The other theory that they've put out in these briefs is associational discrimination. So you may be familiar with associational discrimination in a variety of contexts. It comes up in disability law quite a bit, where someone is discriminated against because they associate with somebody who's a member of the protected class. Slightly different here, but kind of the same theory. The notion is that as with respect to sexual orientation, it's discrimination based on who that person associates with. So it's not necessarily tied up with sexual behavior or anything like that, but it's kind of an attempt to draw an associational theory into this issue. So those are the 3 theories that the EUC keeps putting out there, obviously in the hopes that the courts are going to latch onto them. The sexual orientation theory as a sex stereotype has been adopted by several courts. One recent decision from 2016, EEOC versus Scott Medical Health Center, The judge in that case said, quote, "There is no more obvious form of sex stereotyping than making a determination that a person should conform to heterosexuality." So that is an example of a court essentially adopting whole cloth the EEOC's notion that if you're discriminating on the basis of sexual orientation, it is discrimination because of sex. We have another case, at least one court out of the Middle District of Alabama has also adopted the other two theories that the EEOC has put out there, the sex stereotyping theory, as well as associational discrimination with respect to sexual orientation. Okay? So we're seeing courts adopting a lot of different theories, expanding the meaning of because of sex to wrap additional conduct into the prohibition and finding it to be actionable. What about here in the 10th Circuit? Okay, we still have a case that is good law in this circuit that adopts a more traditional view of sex under Title VII. And it's a City versus the Utah Transit Authority. It's a 2007 case. The district court in that case concluded that the sex stereotyping theory, that Ann Hopkins Waterhouse theory, does not apply to transsexuals. So let me tell you a little bit about the background here. So at City was transitioning male to female, was presenting as a female, but had not had any surgical changes or anything like that. Still biologically was male. She was hired as a bus driver, and as such, she would have to use public restrooms as she was out on her route. Utah Transit Authority fired her, and were upfront about the fact that they fired her because they were concerned about liability from the public if the public ran into a Utah Transit Authority employee who was biologically male using the female restroom. Okay? And they even indicated that she was eligible for rehire as soon as she had completed her surgical transformation, because their theory was then there wouldn't be any risk of liability from the public. So that's the action that they took. District court concluded that the sex stereotyping theory did not apply to transsexuals, and the 10th Circuit affirmed. Okay? They indicated that the traditional interpretation of sex, that is one of biology, holds. And frankly, they basically said, we do not think which bathroom somebody uses is an issue of sex stereotyping. They were not willing to say that the notion that a biological male should use the male bathroom was implicated as stereotype. Okay? They just didn't think Hopkins went that far. So although they punted formally on the question of whether a sex stereotyping theory could apply to a transsexual in any situation, they held that with respect to bathroom usage, it was fine for the Utah Transit Authority to insist that their employees use the restrooms that are associated with their biological sex, irrespective of gender identity or anything else. Okay? So still good law in the 10th Circuit. Certainly not where a lot of the courts are starting to go with these. Who knows how long this will make, be good law in the circuit. But as of right now, this case holds. Okay? So I mentioned a minute ago the 11th Circuit, which sits in Atlanta. It's Atlanta, Georgia, Florida, southeastern United States. Interestingly enough, they had a decision that just came out on Tuesday relevant to this topic, so I thought it would share it with you. Evans versus Georgia Regional Hospital. This was a security guard, I believe, female, homosexual, who filed suit claiming both sexual orientation discrimination as a status and sex stereotyping discrimination. Essentially that she was fired because her sexual orientation didn't conform with sex stereotypes. So what's interesting about this case is that the court amongst itself couldn't agree at all on exactly what theory should prevail here. The majority decision kicked the claim based on sexual orientation discrimination, holding, as most courts have, that as a status, sexual orientation is not protected. Okay? But they remanded, they sent the case back to allow the plaintiff to try to plead a case of sex stereotyping based on the allegations in her claim. But it's the concurring and the dissenting opinions where things get interesting. So the concurring judge kind of tried to back away from what we talked about earlier. Remember, the 11th Circuit earlier had said that if you're dealing with a transgender situation, that's almost always sex stereotyping. because by definition it means that you think someone isn't conforming with sex stereotypes. And the concurring judge tried to back away from that a little bit and cautioned that in his view that is not a legitimate conclusion. That while you certainly may have lots and lots of cases where sex stereotyping and transgender issues will in fact meld, you cannot assume that every individual who experiences discrimination because of gender identity or gender expression is also suffering sex stereotyping discrimination. So I think trying to back away a little bit from the notion that there's always a cognizable claim under Title VII if you're claiming some sort of gender discrimination based on transgender. And then we had a dissenting opinion who concluded essentially, as the Western District of Pennsylvania did just a few months ago, that sexual orientation discrimination is sex stereotyping discrimination. And they're basically indistinguishable for purposes of a legal claim. So this case law is ever changing, ever developing. The courts can't agree with themselves. Arguably, some of the commentary here, particularly by the dissenting judge, is a little bit hard to reconcile with some of this court's previous holdings. So courts are struggling to articulate exactly how these issues should be handled in every situation under Title VII. So just to put a little bit of perspective on this, what I see to be the issue here as employers trying to deal with this expansion of Title VII is we're gradually getting to the point where there is no category, there's no class, there's nothing to point to as being the dividing lines for sure between something that's discriminatory and something that's not. So I put together two slides that kind of, in very, very brief terms, highlights the fact scenarios that have been considered a cognizable sex discrimination claim by some court somewhere, okay? So male disliked because you're male, female disliked because you're female, and the phraseology is mine. That's more the traditional view of sex discrimination, right? Sex and biology. A male who acts too feminine, a female who acts too masculine. That's Hopkins, right? No issues of gender identity, no issues of sexual orientation, behavior alone. A heterosexual, non-transsexual male who dresses like a female, and the same going the other way. That's more of a cross-dressing situation, right? If a male who believes himself to be male, looks male, acts male, feels male, wears a dress to work, is that protected under Title VII? I think some courts would say no, but I think there's some courts who could say yes. Remember the definition of transgender, behavior that doesn't conform with the stereotype. It doesn't have to be tied to a gender identity situation or a gender expression situation, okay? Then the last three, dealing with sexuality, these are or sexual orientation, these are the three theories that the EUC proffered. Again, all three of them have been accepted by at least one court as being actionable on a sexual orientation basis. So then male who became or is becoming female and vice versa, that's the actual transsexual situation, okay? That's at city here in the 10th Circuit. Then males and females who identify themselves as the other sex or gender, and it gets very confusing very quickly what term to use, regardless of whether or not there's actually a change, okay? That's gender expression. And then male who identifies as both male and female, female who identifies as both male and female, okay? I couldn't find a case on this, but it's clearly encompassed within the definition of gender identity and gender expression as the EUC has put forward. And then male who identifies as neither male or female, and vice versa. And you may have heard, there's scientific, papers out there who argue that there are more than just two sexes, right? Or, 7 or 8 or 9. So those theories are not unprecedented, okay? So that's an awful lot of fact situations to have to watch out for as an employer to make sure that your policies and your practices address. Some of these issues are not ones that are obviously going to be, obvious to you as an employer, so that you know what you need to do to try to make sure that you address them appropriately. So it's becoming very expansive very quickly. So I have a couple of unique situations that I wanted to include in this discussion, a couple of that I found. One of them I just found fascinating. This one I think is certainly relevant to some of our clients. And this is the notion of what happens if you're dealing with a company that is owned by an individual or individuals that have religious beliefs that conflict with this expansion of Title VII to include various other issues as well. Now, you may have be familiar to some extent with the Hobby Lobby decision, which was decided under the Affordable Care Act. The whole notion of whether Hobby Lobby, which is owned closely held by a family who has very deep, profound, traditional Christian views, had to conform with the contraceptive coverage provisions of the Affordable Care Act because they believed they violated their beliefs. And the court said, no, you do not have to. And they relied on the Religious Freedom Restoration Act, which is a federal law that essentially says, if the federal government passes a law that on its face seems like it applies to everyone, nevertheless, if it has a substantial burden on the exercise of someone's religion, the court has to apply a strict scrutiny standard, a very intense analysis of the law to determine whether there is a compelling government interest involved and whether the law is the least restrictive means possible of addressing that. Okay? So it requires the federal government to prove that a very compelling need and a very restrictive means of addressing that need if they're passing a law that infringes on religious exercise. Okay? So this whole notion of religious freedom has been applied in the context of what we're talking about. In the case of EEOC versus RG and GR Harrison Funeral Homes, came out last year from the Eastern District of Michigan, we had a situation where a funeral home was owned by a Christian individual. It had a gender-specific dress code. Men had to wear suits with pants. Women had to wear suits with skirts. Okay? The funeral home had an employee who was transitioning from male to female, was presenting as female, wanted to wear a suit with a skirt. And the owner of the funeral home believed that he should not have to, I use the word accommodate because that's not really a word that comes up in the sex discrimination context, but essentially he did not want to have to allow that with respect to his employees. And so the EEOC brought suit against him, and his defense was essentially, this is a burden on the free exercise of my religion. Okay? And the court sided with the owner of the funeral home. And it was a somewhat confusing analysis, but what the court essentially argued is, look, the EEOC needed to try to come up with some way of working this out before they sue the funeral home. And they said the EEOC could have come up with something that would have allowed this individual to dress in a manner that made her comfortable while not infringing on the rights of the funeral home owner. And the thing that the court recommended as well, you could have worked with the funeral owner to see if he would have allowed women to wear pants as well as men, because then at least both men and women would have the exact same dress code applied to them. So although it doesn't really establish any new law, it clearly shows that this whole notion of the Religious Freedom Restoration Act can be applied in this context. If you have a business or an organization that can be said to have a specific religious belief. Okay. And the final unique situation, and I have to beg your pardon, I could not resist a case where the name of the organization supporting the plaintiff was Free the Nipple. Okay? It's also out of Fort Collins, which is my hometown. If you've spent any time there, this does not fit Fort Collins at all. So I had to mention it. I think it's absolutely relevant. I think it highlights what I see to be one of the major practical problems of where the courts are going with Title VII. So, explanation of Free the Nipple. Fort Collins has an ordinance, or had an ordinance, I think it still has an ordinance, that essentially said women cannot go topless in public. Okay? Not particularly earth-shattering as a matter of society and culture. Okay? But Free the Nipple and a couple of individuals challenged it as being a violation of the Constitution's Equal Protection Clause because men could go topless. Okay? So they've filed for a preliminary injunction, which essentially is a means by which they can say, look, we need to stop the enforcement of this ordinance until the court can rule on it. So our very own Judge Jackson over here at the United States District Court ruled on the preliminary injunction. What a plaintiff has to prove to get a preliminary injunction, among other things, is that there's a likelihood that they will eventually win the case. Okay? So Judge Jackson said, you know what, I am going to grant the preliminary injunction. I believe that I will find that this violates the Equal Protection Clause. And if you boil it down, this is my interpretation of what his reasoning was, that the ordinance perpetuates a gender stereotype that women's breasts are sexual and men's breasts are not. He may be absolutely correct, but I look at that from, you know, culture, society, movies, everything that we're used to. And this is an odd statement to me as a matter of calling this a stereotype, which I looked up the definition because I'm like, okay, this isn't computing, right? So in the dictionary, a stereotype is a widely held but fixed and oversimplified belief. So I looked at this for a long time, and I think this highlights what I think is one of the biggest problems with effectively dealing with these new issues in the workplace. I don't think society has caught up to where the court is going. It's not to say the court's wrong. I just don't think society is at the point where this is easily accepted. Okay, and as an employer, you have to deal with those ramifications, right? You have other employees, you have customers, you have vendors that interact with you and your employees. And the fact that, you know, this to me seems incredibly out of step with society. We may get to that point, but we have to deal with that disjunction in the meantime. Okay? So some takeaways. You know, are there any sex or gender classifications left, practically, when you're talking about discrimination because of sex under Title VII? Or are we at a situation where anything that touches on these issues in any way is going to be actionable? And I think the latter very well could be true if the cases continue to develop in the way that they are in some areas. Recent decisions are challenging some very old, well-established social and cultural norms. And again, that's not to say they're wrong, right? You know, we had a much different view of race in the 1960s than we do now. But again, I don't know that society has caught up, and we have to figure out how to meet our legal obligations to all of our employees while dealing with the fact that we're going to have some pushback from people. Number three, I think number three is a very important point. The courts have been pretty clear that when it comes to, for example, the more obvious cases of bathroom usage, dressing room usage, employee or customer discomfort is not a defense. Okay? You cannot say we are not going to allow someone whose gender identity is female, but they are biologically male. We are not going to prohibit them from using the female restroom simply because it makes other people uncomfortable. Okay? That's not going to cut it. So, you know, again, you have to find, you know, ways of dealing with this where we can bridge the notion that you're going to have people who are not necessarily comfortable with these developments. If one of these situations ends up in a charge of discrimination, I say watch out. What I really mean is you're probably in it for the long haul. Okay? The EEOC's enforcement initiatives have focused very strongly on this whole issue of expanding the definition of sex under Title VII. It's a major issue of importance to them, as well as to state agencies. So they take up a lot of these cases. They investigate these cases diligently. You know, they're not necessarily cases that are going to go away if they end up in charge of discrimination. You know, finally, as far as guidance, you know, number one, pause. You know, if you're facing a situation like this in your workplace, you need to stop and remember that the traditional views of how to deal with sex discrimination aren't necessarily going to hold. You know, we're still in a circuit where we have a fairly traditional view of sex as a matter of established law, but that may not hold. And if you have employees in other jurisdictions, that certainly may not be the case. I think training is absolutely something to take a look at as an employer, and very possibly training from a third party, somebody who can come in and speak about these issues with absolute expertise and experience, because I think a lot of people are unfamiliar with them. I certainly am to some extent. And if you can have training and get your entire workforce educated about the various issues that can be related to the definition of sex, I think that is the first step to trying to bridge some of those gaps that still exist between where we are as a society and what the law is saying our obligations are as an employer. So I'm happy to take questions, comments. Yeah, go ahead.
Is Congress working on any kind of items
Well, not right now. There have been situations in the past where there have been bills floated to, for example, include sexual orientation as a protected category under Title VII. All of those bills have not passed. So what we're left with is congressional silence with respect to this. Obviously, we're dealing with a new administration. You may have seen that the bathroom guidance with respect to Title IX was pulled back by the administration, which may signal that this current administration is not as on board with these developments. But as of yet, there is no solution really coming down the pike. Yeah.
In terms of drafting policies for our clients, are we okay with using umbrella term sexual orientation?
It probably depends where you are.
Colorado.
Yeah, Colorado. So yes, as a matter of state law, that is going to encompass the transgender issues as well as sexual orientation issues because of the definition under state law.
But is that, and I'm not an expert in this area at all, so is that not sort of respecting all the other classifications?
Well, at the at the federal level, the courts have continued, in my view, to treat sexual orientation as a different issue than transsexuality or transgender issues. I don't think it would necessarily be obvious to employees what sexual orientation encompasses as a matter of Colorado law. So I would recommend either expanding your definition slightly to reference both sexual orientation and transgender, transsexual, those types of things as well. And obviously, we always love to catch all any other category or characteristic or status protected by law to try to be as broad as possible. But the definitions aren't necessarily going to be instinctive for employees, so I think you're better off being more expansive. Sure.
So what do you do practically speaking, and have there been any cases on this issue where you have an employee who, and I think you talked about this in terms of it's not being a defense if an employee complains about being uncomfortable. I've got a man who's now using my female restroom, or a man who's now using my female locker that my employer provides. So practically speaking, how can you tools to address that in the workplace?
Mm-hmm.
Have there been any cases where they've gotten any late from an employee making that claim? My employer is creating a hostile work environment or something along those lines.
I think there's expense involved. I think the best thing to do in that situation is, when you're dealing with bathrooms and dressing rooms, what is the issue practically, right? It's the biology. Right? People want to feel comfortable with respect to biologically who's using the room, right? Making sure you have individual stalls available, whether it's male or female, is one way of helping to address that. Education, training, cases. There are cases that have gone both ways. The trend clearly is toward, gender identity, for example, potentially trumps biology in some of these cases. And so I think making sure that there are private areas available for all of your employees in those areas is the first step to trying to minimize the arguments they would have on the discomfort level. David?
So I think that in certain instances, I would disagree with you, although I think your presentation is excellent.
Not surprising.
Legitimate non-discriminatory business reasons are defense Title VII lawsuits, and at some level, I think most courts, maybe not all, most courts, I think would at least listen to that very seriously in the context of trying to maintain bathroom separation. The administration has signaled very strongly that they are not going to support EEOC, whether under Title IX, by extension under Title VII, trying to force this odd Obama-era letter, which, it's sparked questions like, well, is this a law? Is this a regulation? Exactly, what on earth were they doing? That's now off the table. So my view would be if you have a man who insists on wearing a woman's dress room, I think you got a discipline issue, and I'll take the case. You come to me when you want to fight an account. On the other issue that is and this actually was reported yesterday, the new head of the EEOC has suggested that EEOC does not intend to walk back, at least not completely, the Obama-era approach to, well, broadly referred to as transgender issues. So how you reconcile the bathroom issues with some of these other issues, I mean, my would probably see some expansion of, at least from the EEOC standpoint, direction that you've identified that some of these recent decisions have taken without going all the way over to bathrooms and locker rooms or relevant, or the sexist is irrelevant.
Yeah, I think the point you made initially is the right one. It depends on the court, right? It depends where you are. In the 10th Circuit, we might have much different defenses available. Yeah,
I mean, ultimately, the Supreme Court's going to take.
Yeah, and it's clearly headed that way. I mean,
sent the bathroom, Virginia high school kid bathroom case back to the Fourth Circuit for reevaluation.
Yeah, and I think it's important that this is not simply an EEOC initiative, right? And what's concerning to me is all of these issues have been explored in the courts, and courts have somewhere adopted all of these various interpretations. And so anytime you have a court starting to speak on the issue, simply what administration you're having or what the EEOC's agenda is becomes a little bit less important, and you have to start looking at what the courts are saying about it.
To the bathroom issue. How long before you see your new hire orientation to have the policy procedures for that? Like if you have a business you I mean, how long before we see things like that?
I don't think that long. I don't know that we're there yet. And that kind of goes back to the very first slide, right? You know, male, female. It doesn't exist anymore, practically. Now, I don't think, you know, I don't think we're to the point where all distinctions have been obliterated and that we need to start having these types of policies. I think it comes down to training. I think it comes down to making sure you have your finger on the pulse of your workforce and you understand that there are issues that are going around and so you can address them. What the administration does, what the courts do, that's going to help determine exactly how far this is going to go in terms of legal interpretation. Yeah, in the back.
So I believe that with the wrong cases, reluctant to accommodate the employer didn't want to accommodate you. But whether employers have any obligation under ADA where an employee may be undergoing some type of medical procedure or treatment, and whether they're required to accommodate that.
Yeah, so as a matter of diagnostics, and the lovely medical diagnostic manuals that we use from time to time, there is a diagnosis for gender identity disorder. It is exempted from the federal definition of disability. Okay, so it is a medical diagnosis. It is not a disability. Okay, so that kind of rides double, right? Because if it was a disability, there would be an accommodation obligation. But because it's not, and I think the reason it's not is because the government doesn't want to suggest that there's anything wrong with having a gender identity disorder, there is no accommodation obligation. So where does that leave us? That leaves us with, exactly what do our policies say? How are we interpreting it? My point is there is no legal obligation to engage in an accommodation analysis when it comes to sex issues under Title VII. That's not part of the legal framework. But in keeping with the theme today, does that fit, right? I mean, do you need to have some sort of accommodation analysis? Practically speaking, maybe. Legally speaking, no. And it just compounds the difficulties for employers in dealing with these issues.
If I could add a follow-up.
Sure.
So would that still hold true to say I'm having a surgery, they change genitalia, and just as a result of the medical procedure itself, regardless of what my motivation is, if my doctor says I can't go back to having a or can't go back to work for 2 weeks, our employers still require them to accommodate that.
If you have a physical or mental impairment in the nature of your surgery that impacts your ability to do your job, yeah. Other questions, comments? Thank you all very much for being here. Enjoy the meeting.
Thank you all for coming. Just one
Oh, I forgot.
If you do not receive your invitation for our upcoming annual seminar, you should give one of us a call. The seminar in Denver is scheduled for May 18th. Thank you. David disagree?
Shocking. I'm using his, so he's helping him with his. Yeah, I know. Ray called me. It's like, just so you know, my thoughts are stopping. See you, Morgan. Happy hour. Yeah. Overturned. Overturned into the oh yeah, there's mud.
I think you put them in the box with your big bag.
Okay. Thank you. It's already been great. Glad to have you. Great. That's our goal. Yep, we just confused the models. Okay. That's horrible. I can find some of our. Yeah, that'd be great. Yeah. I feel so bad about the whole card thing.
It's really good at being.
Thanks very much.
Absolutely.
And I'm Maria Howell, by the way.
Good to meet you.
Nice to
Glad
meet
to have you. Hi. Absolutely.
That was
Thanks for
great.
being here. Thanks for the questions. Hey, Ron, good to see you. Oh, Gretchen, hi.
I will.
All right.
After every other speech, people come up and talk, but they're afraid to come up and talk about sex.
Well, I was afraid to have to get up here and talk about it, right?
It was great. We got to see Howard versus Howard. It was like both got closing arguments. I was just wait for like recross.
I know, right?
I was going to step up and say,
You're out of that. I'm like,
I just met him this morning.
yeah. We work together very well, actually.
Just goes to show, you know, culturally where you get it from.
Nothing's written in stone.
It's a really nice job.
Thank you.
So,
Appreciate it.
appreciate
Glad you're here.
Yeah, glad you guys have us. So
Absolutely. Have a good one. See you next time.
That local case where I don't know, it was a taking business, and then she refused to do the wedding cake for the and you know, in that he it's bought, right?
You did.
Yeah.
It's
So how could the funeral?
I know.
You know, like
I know. And you know, I mean, my argument would be, not that I wanted to support the argument, but my argument would be I was the plaintiff in that case. I want to wear skirts.
Right.
I don't want to be allowed to wear pants. I want to wear a skirt.
Mm-hmm.
So it was a confusing decision, not necessarily one that was
Yeah.
horribly helpful. But
It's certainly going to be a defensive scenario.
yeah.
You know.
But without congressional action or some sort of
Right.
regulation, the court decisions are going to continue to follow.
Yeah.
And it makes it very, very difficult. And there's
Well, I
nothing
guess
easy.
I would just wish that there would be some sort of congressional,
Yeah, whichever way it goes,
I
right?
mean, yeah, just tell me.
Yep.
Yeah. Like,
Yeah. I mean, Colorado is a little bit easier because of the state law requirement, but so much of what we do is not even brought under state law.
Right. Right.
So it should be. So it's going to be a mess for a while.
Yeah.
Fascinating for
Yeah,
me
exactly.
from a legal perspective.
Oh, yeah, absolutely.
Yeah.
Okay.
Thanks for being here. Thank you.
Right.
Brooke, I'm Benita. I'm with you. Denver. Very nice to meet you. Very good presentation. Thank you very much. So, I am with Mile High Sherm, the local HR chapter, and also on the state council. And so we'd like to be able to have speakers in our little cadre of presenters in case certain topics come up in this area. And I know you guys have hosted professional development group meetings here in this room that I've been at before for different topics too.
Keep me in mind. I was happy to help.
I appreciate that because I cannot tell you how frequently the question does come up, and if I have somebody, because what I'm doing is I send everybody to David.
You can talk about everything though.
Yeah, he can. I use him for international. When we need international credit,
There you go.
David, can you talk on something international? And I just did it to him too.
There you go.
Yeah.
So,
Thanks for being an expert.
but she went to my law school. Okay.
Oh, you did, huh? Oh, well,
Even though
that's,
she's a Coloradoan.
well, everybody has to be from someplace. And for college.
I came back.
Yeah, she came back. What's important.
But I tell you, one of the things about doing at Sherman Howard is the depth and sort of intellect in our, throughout the firm, particularly in the employment.
Well, and I got the email, to mark the day for the upcoming employment stuff at the convention center again, and I have had 3 or 4 folks that, like, within the last 2 weeks have reached out to me and said, have you seen the date? When's that going to happen?
Oh, yeah, cool.
So it was interesting because then I forwarded it and said, did you guys get this? Did you see it? Because there's a lot of us that we just wait for you guys to do that every year.
If you have folks let us know, we certainly can make sure they're on our list if they think they'd be interested, or have them contact us if
And
they
I
are.
know they all have attended before, so I'm sure that, and that's probably what prompted them, and I'm sure they got it, and I forwarded it. But if they come back and say I didn't get it, then I'll make sure that they
And there'll be some follow-ups.
circle back around. Yeah,
But good.
so I'm looking forward to that as well. All right.
Good.
to meet you. Thank you for
very
being
much.
here.
Nice meeting you.
All right, good job, Brooke. I think we got order.
I will. I haven't seen it yet in detail, but I'll take a look at it.
I enjoyed it. Thank you so much.
Absolutely, thanks for being here.
That was incredible. I was telling Lisa, I work for Kaiser.
Yeah.
So our issues aren't necessarily bathroom, although we have single bathrooms that have been trained.